Insanity is the definition of continuing conduct and expecting a different result. Everyone here knew that my client needed more treatment, and yet there was more of the same. Now, I'm not saying that my client is perfect. I'm not saying that my client essentially hasn't been difficult to deal with, but I don't think that that's a basis to revoke her parole.
We are about to watch a parole revocation hearing out of the state of Connecticut, and she is represented by the one and only attorney, Famigaletti, if I'm pronouncing his name correctly. I don't know how you feel about him, but I do think that he is one of the more competent defense attorneys that we have seen. With that, let's jump in.
No, thank you.
So you have important rights. I'm going to review that with you. Your right to have an attorney present. You have counsel here. You have a right to receive the written notice to charge the violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you before this hearing. You have a right to submit evidence to support your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes, ma'am.
Okay. So you now review the charge the state your parole officer is bringing against you and the information underlying each charge. Pio Castillo, can you please read the charges?
Oh, can you hear me?
Yeah.
Okay, you want me to read out the charges?
Yes, please.
Okay, and charge 1, halfway house placement. Do you want me to read all the details?
Yes, I want you to read everything you wrote for the charge.
Oh, okay.
Mhm.
Upon your release from your CI, you sign your special parole conditions indicating an additional stipulation of halfway house placement. You tested positive for marijuana on 5/20/23, 5/25/23, 6/1/23, 6/16/23, 8/24/23, 11/4/23, 11/16/23, and 11/17/23. At which you failed to follow through with the proper protocol for marijuana use. On 11/16/23, you lied to the halfway house staff indicating your transportation was your bail driver through bail service. This information was found to be inaccurate as the bail driver was transporting you outside of the bail service. On 12/29/23, you returned to the halfway house with unauthorized items, which were an indication that you went to the store without proper authorization from the halfway house. You refused to surrender the items and proceeded to your room with the unapproved items. On 1/2/24, you were standing outside of the halfway house on the telephone without authorization. When directed to enter the halfway house, you became argumentative and disrespectful, stating, quote unquote, "Are you fucking serious?" You entered the halfway house and continued your verbal aggression towards the staff. On 1/3/24, you were directed to leave the halfway house case manager's office after becoming verbally aggressive with the halfway house staff. On 1/19/24, upon arriving to the halfway house, you were directed to enter the building. Despite this direction, you lit your cigarette and disregarded the halfway house staff direction. You proceeded to smoke your cigarette and remain in front of the building until you finished smoking your cigarette. On 1/19/24, you were disrespectful to a halfway house staff member and utilized the derogatory statement, quote unquote, "What are you talking about, bitch? Are you serious?" Additionally, you ignored the direct order to provide another parolee with privacy while medication was being administered. On 1/21/24, you were instructed that the halfway house was on lockdown. Despite this, you disregarded and proceeded to go to the kitchen knowing this was not allowed. For a period of 15 minutes, you were told to return to your room and did not obey the staff directions. On 1/21/24, you demanded a cigarette break from the staff at the halfway house. When you did not receive authorization, you became verbally and aggressive towards the staff. On 1/21/24, you threatened another offender at the halfway house by making threatening statements such as, quote unquote, "Pick a time and place to fight." On 1/22/24, you engaged in a verbal altercation with 2 other parolees and threatened one of them at the halfway house. On 1/22/24, while in the community, you contacted the halfway house requesting authorization to stop at the store, to get cigarettes. The request was denied. Despite this and being on GPS monitoring, you went to the store and were, quote unquote, out of place. On 1/22/24, you were directed by staff several times to leave the front office. However, you refused to do so for about 18 minutes from 10:30 p.m. to 10:48 p.m. On 1/29/24, during a group meeting at the halfway house with the Women's Against Mass Incarceration, the WAMI program, you were disruptive and disrespectful, causing chaos between other parolees and calling the facilitator a quote-unquote fake-ass bitch. A few offenders were upset and walked out of the WAMI group. On 2/1/24, you demanded your medications before it was time to administer them to you. When denied the medications before the scheduled time, you became argumentative with the staff. On 2/1/24 at 7:27 p.m., while in the community, you were supposed to be picked up by the halfway house staff. Instead, you arrived in a black truck stating it was your quote-unquote bail transportation, but this was unable to be verified by the halfway house staff. On 2/2/24, you were out in the community demanding the halfway house staff follow your direction with regards to choosing your dispensary for the marijuana. You contacted the halfway house a significant amount of times, being argumentative and disrespectful towards the case manager and other staff at the halfway house. You were also instructed to return to the halfway house, which you did not until 2 hours after you were scheduled to have returned. On 2/6/24, you were engaged in a verbal altercation with the halfway house staff after demanding they transport you to an appointment. You were very disruptive and argumentative. On 2/7/24, while at the halfway house, you engaged in a verbal altercation with another offender when she asked for privacy at the medication window. On 2/9/24, you became upset at a staff member and were heard yelling in the hallway, quote unquote, Liz is a bitch and a stalker, repeatedly until you got into your room. On 2/21/24, you walked out of the halfway house without being signed out and yelled, quote unquote, bye. You were instructed to return to the halfway house to be properly signed out. You began to yell and scream, saying you had to, quote unquote, fucking leave. You continued your verbal aggression and intimidating behavior towards the halfway house staff. As a result, the halfway house staff contacted 911. Despite being instructed to wait for your pass, you left the halfway house without appropriate approval via a pass. The state police trooper Cardenas responded to the halfway house, but you had left the facility. On 3/22/23, you signed the special parole conditions, which included an additional stipulation of quote unquote mental health. Oh, we're going on to the second charge. My apologies.
No, it's okay.
Charge number 2 is mental health treatment. On 3/22/23, you signed a special parole condition, which included an additional stipulation of mental health treatment. Throughout your recent parole supervision, you led the halfway house staff to believe the app program was adjusting your mental health, which was misleading. On 1/31/24, the App Foundation program reported medication management for psychotropic medications for buprenorphine treatment for opiate dependence. The App program recommended you attend individual weekly therapeutic sessions elsewhere.
Thank you. And the state filed the following exhibits that are pre-marked for identification purposes as signed, Exhibit A, signed statement of understanding and agreement, conditions of parole. B, halfway house agreement, women and children's halfway house. Exhibit C, Lucy Barney, Women and Children's Program Residential Handbook. D, halfway house incident report, positive for marijuana, 5/20/525/6123. E, halfway house incident report, positive marijuana, dated 5/25/23. F, halfway house incident report, positive for marijuana, 6/16/23. G, halfway house incident report, positive marijuana, 8/24/23. H, halfway house incident report, dated 11/4, 11/16, 11/17/23. I, halfway house incident report, misleading information by offender regarding transportation, 11/16/23. J, halfway house incident report, out of place, 12/29/23. K, halfway house incident report, argumentative, disrespectful, 1/2/24. L, halfway house incident report, verbal aggression to halfway house, 1/3/24. M, halfway house incident report, unwilling to follow staff directive. N is halfway house incident report, unwilling to follow staff directive. And O is halfway house incident report, demanding a cigarette break. P, halfway house incident report, threats towards another offender. Q, halfway house incident report, verbal altercations with other offenders at the halfway house, dated 1/22/24. R, halfway house incident report, out of place. S, halfway house incident report, causes group disruption, profanity towards group facilitator. T, halfway house incident report, verbal aggression towards staff. U, halfway house incident report, out of place. B, halfway house incident report, verbal aggression towards staff, out of place. W, halfway house incident report, verbal altercation with halfway house staff. X, halfway house incident report, verbal altercation with halfway house staff. Y, halfway house incident report, verbal aggression towards staff. Z, halfway house incident report, verbal aggression and intimidating behavior towards halfway house staff. State police contacted 2/21/24. Double A, letter from Career Resources, halfway house requesting offenders removed from halfway house. 2/5/24. BB, GPS agreement dated 1/12/24. CC is state police troop report 9804. DD is Connecticut Board of Parole Remand and Custody Order 2/22/24. Double E is notice of parole violation. Double F is parole violation report. Double G, notice of parolee rights, and double H is apt program letter. Did you receive notice of parole violation report, and the other documents I marked, and did you review them?
Yes, yes.
Council shall have the following exhibit pre-marked for identification purposes as Defense Exhibit 1 treatment letter. Do you need to continue this hearing to obtain any additional evidence?
No, I do not.
Okay, we have no witnesses. So at this time, the state will have an opportunity to make a short statement and testify with respect to probable cause and severity of the allegations. I'm just going to swear in Pio Castillo as well as Ms. Morris in case you guys would like to speak today. So can you please both raise your right hand for me? You solemnly swear or solemnly sincerely affirm as the case may be, the evidence you shall give concerning this case shall be the truth, the whole truth, nothing but the truth, so help you God, upon penalty of perjury?
Yes.
Mrs. Castillo, I do.
Yes, thank you. So right at this time, Pio Castillo would like to make any comments regarding anything. Would be your time to speak for this hearing.
Yeah, so this is not the first time that, the video is kind of delayed. Am I correct?
Yes, I can hear you clearly.
Oh, okay. So this is not the first time that Bethany Morris has been violated. She has previously had top placement and had gone back on violation. Has been remanded several times due to her behaviors and substance abuse issues. I'm not sure what needs to happen next. I definitely think she needs some consequences or some treatment or something to address these long-standing behaviors with her anger and mental health. We have placed her in all of the different halfway houses, and the behavior continues. During my supervision period, there was a time frame where we, Bethany Morris is very likable, but she has significant behavior problems that have caused her not to succeed in all of these different settings, whether it be out in the community, which she has been in a sober house before, or whether it be in all of the halfway house placements. If her behavior is very disruptive to everyone in the halfway house, it's disruptive to the staff members. And she pretty much, in my experience in working with her, is very, very manipulative. We have talked, Bethany and I have talked significantly about these issues. She acknowledges these issues. Despite this, her behavior continues. I tried for the most part to work with her because she did have a baby in the halfway house, and we were trying to make her be successful in this setting. But the behavior continued, as indicated on all of these IRs. The misconduct that I'd issue her were later on because we were trying to, really put forth planning for her. How can we change these behaviors? How can we modify them? How can we make her successful? Tapping into her history, right? All of these behaviors she's shown in all the other halfway houses. We were unsuccessful to get her to a place where she can seize all these behaviors.
Thank you.
It's my turn now.
Yeah, it's now defense opportunity to respond and testify with respect to probable cause and severity of the allegations at this time, if you'd like to.
Yeah, I just have a few questions of the witness. Exhibit HH, I'd like to draw your attention to, Pio Castillo.
I'm hearing you. Hold on.
Okay, yeah, I'm gonna give you time to get to the exhibit.
Okay, give me a second. Let me,
Yeah, there's a lot of exhibits. Yeah,
yes,
HH.
HH, which is what exactly?
It's the App Foundation letter to you from Jessica Means and Catherine D'Angelo from the App Foundation on January
Okay.
31st.
All right, just give me a second because I have to go into case notes to get that. because I don't have the packet in front of me, so. I know what the letter says, if you want to continue.
Okay, so just not looking at the letter because you don't have it in front of you yet. Another question is, as part of your recommendation, you made a recommendation that you thought that she might be better served in the mental health unit supervision, correct?
Correct.
And the letter itself that I'm referring to, the App Foundation letter, which is dated January 31st, and she was remanded on February 22nd, almost a month later. App Foundation does not provide individual therapy, but rather medication management and substance abuse counseling for the buprenorphine program. It is recommended at this time, which is consistent with what you said, that Ms. Moore seek out and engage in weekly individual therapy to focus on treatment for mental health, including current life stressors and PTSD. So my question to you is, was a psychiatrist appointment or mental health treatment set up for my client, knowing that all parties knew this is what she needed, because you just testified that she had significant behavioral problems and her behaviors over all of this time that you've known her has continued. Nothing has changed. So in order to have change, something has to be changed, which would be referring her to the mental health unit or referring her to mental health treatment. So my question is, between January 31st and the date of her remand, February 22nd, where were the appointments that were set up for her to go see a psychiatrist or begin mental health treatment?
Okay, without getting deep into the DCF involvement, I would just say that she has DCF involvement. There are specific steps. I have had meetings with DCF regarding her daughter. Okay.
I don't want to get into that, but what I would like to know is
I'm going there. You have to you can please give me an opportunity to go there.
Okay, sure. Sorry.
Because our big part of my work was collaborating with the community. And because she has DCF involvement, obviously we don't want to duplicate services, right? And we want these services to be very effective. I'm not going to just refer her to a program just because, right? So DCF has specific steps ordered in juvenile court that she has to follow through with in order to regain custody of her daughter. In these specific steps, it's outlined that she is to attend their mental health treatment and evaluation. They are in their process and have been in the process. She has a slew of services with DCF. They're in the process of referring her, and they actually have identified someone for her to see.
She had two appointments.
No, you go ahead.
In the midst of all of this, she was remanded. So they are working. I've had several meetings with DCF.
Okay. Yeah, I had known that she had appointments, and unfortunately, because she was remanded, she missed those appointments with the psychiatrist, correct? Or the workers? She had one on 2/21, and she had one on 2/28. And then she had 3 sessions at AIC that unfortunately got canceled. So with Amia Walker, I believe.
Right. So let's just say that it wasn't her doing. It was Morse's behavior that caused her to miss those appointments. I'm very confident that I've done everything I can to help her, and I have worked diligently with DCF to make sure that she gets the appropriate services. DCF was working on that, and Morse is very aware of that.
Right, but I'm just curious what Parole did in terms of getting her, because it's my understanding that she was remanded on the 22nd, and so that's why she missed her appointment on the 28th.
Well, first of all, I didn't know about this appointment on the 28th, and when we remand, that's not taken into account. I mean, we had to remand her because of the significant issues with her behavior.
Okay.
So I think that's a question for you to pose to DCF.
Okay.
I answered your question as far as why she didn't get the treatment between that time frame.
Thank you. So
you're welcome.
I really appreciate it. I'm not attacking you. I called Sophie.
Not at all.
I called Sophie Hale of DCF. I called her and left a voicemail on 8/24, at 8/24 on 3/4, left a voicemail. She called me back and said, quote, "I don't have any information for her defense. We do not get involved in legal situations. End quote. So I have absolutely no way. They did not cooperate with me in any way, shape, or form as to find out what type of mental health treatment they were providing her or not. This has nothing to do with you, Officer Castillo. It's just I reached a brick wall, and I think that all parties are of the opinion that what my client needs is behavioral treatment and significant mental health supervision. So as to the charges that I want to address, thank you very much. I have no further questions. As to the charges that I wish to address, it's uncontroverted. I don't believe anyone denies the fact that my client had a marijuana card. And in fact, she states she gave it to Cynthia Sparks at the halfway house in July. There were 8 marijuana positive tests. And as to the preponderance standard, the first 4 were within 1 month. And there are no levels listed in any of the tests. So marijuana stays in your system for approximately 30 days. So all we can consider for 520, 525, 61, and 616 is one possible use because we have no levels. And she had a card. Second of all, there's an 824, which is beyond. So that would be allegedly a second use. And then from 11-4, 11-16, and 11-17, those are all within 30 days. So we're talking about 3 uses of marijuana. I think it's important to note that she was paroled on 4/5/23 and remanded on 2/22/24. Okay, so that's approximately 10 months. And if there are 30 days in a month, that's approximately 300 days of supervision. And if you look at the halfway house placement and you count the number of days where she had issues, there are 19 days. 19 days listed out of 300. Some of these happen multiple times a day. Some of these have to do with her wanting to use a cigarette. Some of these have to do with a term that I never really heard, which is verbally aggressive. Did she swear a number of times? That's what they're saying. Did she call someone a bitch? That's what they're saying. I'm going to go one by one. As to her lying about the bail service, there's no statement in Exhibit I that says that she lied. As to the 22923 brought unauthorized items from a store, no one saw her go to a store. It's a complete assumption, and she's telling us that DCF supplied her with those items. That would not be consistent with her going to a store. DCF provided her with those items. As to 1-2 use of a phone without permission and her giving an attitude, well, she was told that she could talk to her lawyer in private, and that's what she was doing. She was outside talking to her lawyer in private on the phone. As to the 1/3 quote unquote use of the term verbally aggressive with staff, there's no aggression. She went to an office and said, could you get out? She raised her voice. She said, could you get out to one of the parties in the office because she wanted to speak privately with the other party in the office. These are a number of violations listed over and over and over of a course of 300 days. These are 19 days. And I think it's very important to know that everyone has due process rights. Everyone has a right to be put on notice that they're doing something wrong to change their conduct. And what is the notice that a client is given that her conduct needs to be changed? Well, that would be a misconduct report. During the 300 days, if we look at the report under graduated interventions and sanctions, my client received 2 misconducts. During 300 days. The gist of the argument is that my client has serious behavioral problems that they've known about for a long time. My client has serious behavioral problems and acts out that they've known for a long. There's no allegation of violence here. There's no allegations that she was violent towards anyone here. There's no absconding here. She may have been late, but there's no permanent absconding. She was always monitored at the halfway house. My client has been at various halfway houses. And my client has argued in a number of these because she was having cigarette bumps. They called the facilitator a fake ass bitch. And in the report, it says that she interrupted and was talking all about herself in a group treatment group. Well, what else is she supposed to do in a group treatment? She's supposed to talk about herself. She's supposed to talk about her problems. So if in fact what is necessary for my client, and it's consistent from the Foundation's referral, insanity is the definition of continuing conduct and expecting a different result. Everyone here knew that my client needed more treatment, and yet there was more of the same. Now, I'm not saying that my client is perfect. I'm not saying that my client essentially hasn't been difficult to deal with, but I don't think that that's a basis to revoke her parole. I think it's a basis to refer her to a mental health unit. I don't think any of these are sufficiently serious to incarcerate her. She's been incarcerated now since 2/24. We've known since January, and probably we should have known before, that what she needs is mental health supervision. I think she should be released. I think she should be referred to the mental health unit. I think she should continue with DCF with whatever she's doing at DCF, because no one was able to talk to me about it. I have a letter from the Boys and Girls Village that I'd like to read. Ms. Morse has participated in Circle of Security, I'll highlight it, parenting from January 19th to February 15th. Ms. Morse has consistently and actively participated in sessions and practiced concepts with me, the parent educator. She is introspective and reflective during sessions, sharing her parenting experiences and the lessons to be learned about becoming the best mother she can be. The client regularly takes accountability for past mistakes, which are being transformed into learning initiatives throughout her sessions. She has reflected on her strengths as a parent and remorse towards the needs that she was not meeting for her children. It is evident that Ms. Morse has done substantial inner work and is continuing to reflect and learn. My client's going to be monitored for a long time. I just don't think that because we need a change in application, there's been 2 misconducts. How is she to be put on notice that this was going to happen? There's been 2 misconducts. My client needs mental health supervision. I don't believe that we should go forward with a revocation hearing. I think she should be re-referred to the mental health unit. I don't believe it's sufficiently serious enough to go forward with a revocation. And I certainly don't think jail is appropriate for my client. Thank you for your time and consideration.
You can speak. You can speak before I make. If you'd like to say anything else.
Yes, please. So I know that I completely, hold on 1 second. Hold on. I'm so sorry for that. So I want to just, before you make a finding, so I know that the attorney, you say that there was only 2 misconduct issues for her, 2 misconduct reports, and I completely get that. However, I have tried diligently and I have put so much effort into helping Bethany Morse with her behavior, despite that she continued on. So I'll say that to that. The other part is that her behavior, I know that the marijuana use, you mentioned that. She notes that there was no marijuana card produced from what I see during the time when she was testing positive. We need to understand that it's a fact, it speaks to her compliance. The rules are the rules at the halfway house. She understands what they are. Marijuana cards, and it has to be in a pill format, and it has to be delivered to the halfway house. Despite that, she wanted to go ahead and come up with her own rules, test positive without producing and going through the proper channel. That's why I mentioned the marijuana use in there. And it affects all the other females in the house who are working on their sobriety. As far as her behaviors, I know you outlined each one of them. You were going through each one of them, and yes, if you take one, it may sound petty to the unknown, right? To the person who doesn't know, who hasn't observed Bethany. But when you put it all together, the disruptive behavior is very chaotic and it's not conducive for people in a halfway house who are trying to be in recovery, to try to, have their, transition into the community. It's very disrupting. I just wanted to make it a point before you make a finding. And coupled with the fact that this is not her first time around. I mean, we have seen this behavior in all of the different studies she's been on since she's been on supervision.
Thank you. You want to speak? You may this time if you like to.
Okay, thank you. I appreciate everyone here today. I just want to point out that I do realize that my actions or my attitude at certain points in the halfway house were not conducive, right? That doesn't mean I wasn't trying. I do want to say I do appreciate Officer Castillo, but I do want to say that, like, 1 second. Regarding the marijuana, I didn't sign those conditions until 11/20. Never was it in writing of how I was supposed to. I asked several times. I got my replacement card on June 9th. I went to Case Manager Sparks. I said, how are we supposed to do this? Yada, yada, yada. We've had several conversations about it, but never was it in writing. I signed on 11/20 that I was to follow protocol. You have that, where is it? 1 second. There was a new agreement of the halfway house signed on 11/20/23. That is when the marijuana protocol was to be introduced. Since then, have I had any dirty urines? No. I signed them and I respected them. I understand what they're saying. When I lost my daughter on the 6th of December, you can see my behavior went upticked. I'm not saying that I don't deserve any consequence. What I'm saying is jail is not the answer. I've been here for almost a month. I see what I need. Effective communication, psychoanalytic groups, psychoeducational support, skill building, major development, reoccurring. I had a TBI in 2016. Never did I have DBT. I know I need more mental health treatment, but jail is not going to give me that. That's all I have to say.
Thank you.
Nothing further.
Thank you. All right. So what I'm going to do next is I'm going to out to my findings, taking into account testimony and evidence that was presented. I am going to go through the violation and I go by dates. So I make a finding of probable cause on charge 1, halfway house placement. I'm going to go through these dates to make this clear what I make findings on, what I do not. On parts of marijuana, test positive marijuana, I make a no finding on all of that. On 11/16/23, I make a finding. On 12/29/23, I do not make a finding on that date. I make a finding on 1/2/24, 1/3/24, 1/19/24 on the second part. On the first part, on 1/19/24, I do not make a finding. On 1/21/24, I do not make a finding on that date on the first part. On 1/21/24, the other 2 parts, I do make a finding. I make a finding on 1/22/24 on the first 2 parts of that. I do not make a finding on the 1/22/24 on the third date part. I make a finding on 1/29/24. I do not make a finding on the first part of 2/1/24 regarding medication. On 2/1/24, the second part, I do make a finding on that. I make a finding also on 2/2/24, 2/6/24, 2/7, 2/9, and 2/21/24. This is based on exhibits I have received: IKNMOPQRSUB, WWXYZ, and CC for those dates that I have listed. On charge 2 condition, additional condition mental health treatment, I make a no finding probable cause based on that charge not meeting the elements. As the offender was not given information for treatment participation and did not fail to participate in the treatment as there was no instruction to participate in mental health treatment. That was noted in any of the evidence. So, and it is noted the offender is taking medication. I do find the acts of serious enough to warrant revocation. I determine you should be detained while you wait for revocation hearing. I'm going to bring you back very shortly and we're going to determine if there's a violation or not. So I will see you very soon, because you have a technical violation. So I will schedule you soon to bring you back.
Thank you so much.
And then I'll talk to you then and we'll address those, dates that I have listed.
Thank you very much.
Okay.
Thank you so much.
Okay.
Thank you.
Thank you.
Thank you.
Have a good day.
Thank you very much.
Bye-bye.
Officer Gladue? I'm all set.
Okay, so let's unpack that. One is I'm pretty sure that what it is that they found the violation, but now they're going to bring her back to determine how much time she's going to get, and that may happen in the next week or so. And if so, and if it's maybe I'll send an update video for this. But you know, her attorney, we have seen him represent the worst kind of cockroaches, and when he does that, I really just despise him. But I think I got to give him credit where it's due, and he's good in my opinion. I mean, he's thorough. He makes the right points. He puts up good arguments. And I just wonder what they're paying for a public defender to help with these cases, and why has he not found a career as a prosecutor? We could use him on I know what I'll say, the right side of the bench, but I think everyone deserves proper representation. I don't want to take that away from him, but it's at the same time, seeing him represent the worst of the worst makes it hard for me to forget that. But in this case, I actually do think that this woman does need mental health. I'm not justifying anything that she's doing. I feel for the parole board for the parole officer who came up and spoke, and you know, everything that she's talking about with the halfway house and how this person is a huge disturbance to the halfway house. Man, the way the attorney broke it down into tiny little bits by saying there's only two reports, and for each of the medical marijuana, you know, even though it's not that, but it stays in your system for a month. And then if you break it down to each one, it's like, well, she smoked a cigarette. And it's like, are you really going to send her back to prison? But now I look at her reports that Richard sent, and it seems to be a history of some serious, you know, narcotic problems, but also kind of like, you know, I'll read some of the reports, but she's like that crazy woman that you see running around in the street, and you call the cops, and it's like report after report after report of her doing things like that. So let me read a few of them to you. And I'll just read it from the notes, because they have dates and stuff, so I don't like to screen share it. So she has one on 1/16/2015, engage police in pursuit, 1 year jail, execution suspended sentence. Okay, so that's not good. Then she was revoked in 2/28/18, 5 months jail sentence. Then she has reckless endangerment, 2nd degree, 6 months jail, execution suspended probation, 18 months. She was revoked. She has Mohegan Tribal Police, arrested 1/19/16 for cannabis, sentenced 1 year jail. She had half an ounce of marijuana, which is legal now. She got a year in jail, but it was a suspended sentence, probation 2 years. Of course, she violated. Then she got 90 days in jail for violating or something. She has burglary, 2nd degree, 30 months jail, 90 months special parole. I mean, the system with her, she just keeps getting in and out, criminal mischief. But so let me read to you the actual. So on September 26, 2014, a city woman was arrested for endangering her young child. Now, this is, you know, when you hear endangering a child, all the worst comes to mind. What she did was bad, but it wasn't is far cry from it's on the bottom of the threshold. Let's put it that way. So after she admitted to smoking marijuana while holding her naked baby, that's what basically. I'll just read the details. So on September 25th at 11 a.m., police were called to home on Carriage Crossing about domestic complaints. They found Bethany Morse, 24, at Carriage Crossing, holding her 9-month-old son, who was unclothed, according to the report. Her husband, the report indicated, had left the area. The home smelled of marijuana, and a search turned up 0.6 grams. That's it, 0.6, not even a gram, of pot in the bathroom, which was full of smoke with burnt ashes in the sink. Morse allegedly told officers a little weed never hurt anyone, and admitted to smoking it while having the baby with her the entire time. Officers reported the child didn't even have on a diaper. She was charged with the risk of injury to the child, the second-degree failure to appear, and outstanding warrants. Now, I'll tell you that if I'm an attorney here, I'd be like, wait, she has her baby with her. She's inside. The 0.6 gram of pot was found in the bathroom, which means that she has the wherewithal to smoke in the bathroom to keep the smoke away from her child. And whether the baby's naked or not in the house is that can't be considered, it's in your house. Maybe the baby, you're airing the baby out. Maybe you're I could flip that thing on its head so quickly. I have a brother who's basically a hippie, and he would do all those things, and he would never come across, and his wife would never come across as someone who would neglect their children. So a woman who reportedly told police that this is another report, 2015, a woman. So for that to be as neglect of a child, I'm not cool with that. Let's put it that way. But, at the same time, if you look at her track record, so a woman who reportedly told police a little weed would never hurt anyone after smoking while holding her 9-month-old infant appeared again in court Monday. And again, that's not necessarily true. It seems that she went to the bathroom and smoked, and then when the cops come, she picked up her infant. But after initial incident, Bethany, 25, entered the courtroom from lockup on April 20th, the unofficial marijuana smoking holiday known as 420 or Weed Day. According to an arrest warrant, police responded to a call of domestic disturbance and found a burning marijuana joint in her bathroom. She was holding her naked infant at the time. Morse was charged with the risk of injury to the child. So this is just a continuation. You ask me, that I'm not cool with those charges. I'm straight up not. So it's like you're going to take a mom away from her baby and lock her up based off of what? Okay. And what's funny now is they can't even, now pot's legal, so they couldn't even make those charges. It's, I'm sorry, but that's disturbing to me. That really is. Anyways, Morse is also going through court proceedings for a shoplifting charge from March 14th, with 4 additional failure to appear charges, according to the state judicial website. Morse also case in Manchester and away through court for first-degree reckless endangerment. Anyway, so I'm jumping in from the future. This hearing took place March 19th, and then they finally had now the official hearing on April, which is what we're going to watch now. So it takes place on April 9th, and it's like the official revocation hearing. And so we'll get to go through the motions and see what that's like. With that, let's jump in. And of course, thank you, Richard, for tying it all together to make it easy to bring these to you, connecting the dots.
Good morning, Ms. Morris.
Good morning.
We'll be right with you.
Okay.
Hearing concerning Morris Bethany, number 407-380, today's April 26, 2024. This hearing is being conducted via video at the BOPP Central Office in New York Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Yes, Bethany Morse, 407-380.
Thank you. And we have a parole officer present. Can you please identify yourself?
Parole Officer Jessica Castillo for the Women's Reentry Unit.
Thank you. And we have counsel here today. Please identify yourself.
Yes, good afternoon, Attorney Robert Famigletti, the full revocation unit.
So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better reader evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing you, place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, thank you.
Okay, so important rights today, I'm going to review that with you. The right to have an attorney present, you have counsel here. You have the right to receive the written notice charge of violation. Did you receive the written notice?
Yes.
You have the right to view the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
And we will now review the charges that the state your PO is bringing against you and the information underlying each charge. POC, I will read the charges because due to the no findings I made on certain dates at the preliminary hearing, I'm going to read the charges that we're actually looking at today.
That's fine.
So just to make that easier, because I'm not sure you have all those marks.
Okay.
So the charges that we are looking at, that are not taken into consideration today, are the first part, for the positive marijuana tests are not taken into consideration. The date of 12/29/23 is not taken into consideration. The dates of 1/19/24, 1/21/24, we have 1/22/24 and 2/1/24, and a no findings made on mental health treatment at the time of the preliminary hearing. So those dates and those charges are not taken into consideration at today's hearing. So we are looking at the charges of additional conditions, halfway house placement. On 11/16/23, you lied to the halfway house staff indicating your transportation was your VAO driver. Through VAO service, information was found to be inaccurate as a VAO driver was transporting you outside of VAO service. On 1/2/24, you were standing outside of the halfway house on the telephone without authorization. When directed to enter the halfway house, you became argumentative, disrespectful, stating, "Are you fucking serious?" You entered the halfway house and continued your verbal aggression towards the staff. On 1/3/24, you were directed to leave the halfway house case manager's office after becoming verbally aggressive with the halfway house staff. On 1/19/24, this is on the second part. There's 1 and 2, so the 2 is only taken into consideration. You were disrespectful to a halfway house staff member and utilized a derogatory statement. Why are you talking about bitch? Are you serious? Additionally, you ignored a direct order to provide additional parole with privacy while medication was being administered. On 1, for what?
I thought the first one was, and the second one wasn't.
The first one on what?
119.
The 119 with,
Upon arriving to the halfway house, that one was made a finding, and the second one for 119 was not.
I have it marked different.
So do I.
I have it written down. Let's see. I made sure I wrote this.
I'm sorry to interrupt.
No, that's okay. It's all right to clarify. And this was, you're talking about the 119 date, right?
Right.
Yeah, so no, it's the second one. It's no on the first one with the cigarette.
That's right.
Okay.
Yeah. So,
Thank you.
yeah, 120, let me see. It's a computer, please. Just clarify, let me make sure. And we have 1/21/24. You demanded a cigarette break from staff at the halfway house when you did not receive authorization, became verbally aggressive towards staff. On 1/21/24, you engaged in a verbal altercation with two other parolees and threatened one of them at the halfway house. On 1/22/24, while in the community, you contacted the halfway house requesting authorization to stop the store to get the cigarettes. The request was denied. Despite this and being on GPS monitoring, you went to the store and were out of place. On 1/29/24, during a group meeting at the halfway house, the Women's Against Mass Incarceration Program, you were disruptive and disrespectful, causing chaos between the other parolees and calling Cylinder a fake ass bitch. A few offenders were upset, walked out of the whammy group. On 1/24 at 7:27 p.m. while in the community, you were supposed to be picked up by the halfway house staff. And said you arrived in a black truck stating it was a Bayo transportation, but was able to verify by the halfway house staff. On 2/2/24, you were in the community demanding the halfway house staff follow your direction with regards to your choosing of a dispensary for the marijuana. You contacted the halfway house staff, you contacted the halfway house a significant amount of times, being argumentative, disrespectful. Put the case manager and other staff at the halfway house. You were also instructed to return to the halfway house, which you did not until 2 hours after you were scheduled to have returned. On 2/6/24, you engaged in verbal altercation with halfway house staff after demanding they transfer you to an appointment. You were very disruptive and argumentative. On 2/7/24, while at the halfway house, you engaged in verbal altercation with another offender when she asked for privacy at the medication window. On 2/9/24, you became upset at a staff member and were heard yelling, and the halfway house was a bitch and a stalker repeatedly until you got into your room. And on 2/21/24, you walked out of the halfway house without being signed out and yelled bye. You were instructed to return to the halfway house. You properly signed out and began to yell and scream, stating you had to fucking leave. You continued a verbal aggression and intimidating behavior towards the halfway house staff. As a result, the halfway house staff contacted 911. Despite being instructed to wait for your pass, you left the halfway house without the appropriate approval via pass. State police trooper Parole responded to the halfway house, but you had left the facility. And the state has filed the following exhibit for the pre-mark for identification purposes as Exhibit A, signed statement of understanding and agreement conditions of parole. B, halfway house agreement, women children's halfway house. C, Lucy Barney Women Children's Program Residential Handbook. D, halfway house insert report. Halfway house insert reports are Exhibit D through Exhibit C. Exhibit AA is a letter from the Career Resource Halfway House requesting offenders removal from the halfway house. Double B is GPS agreement dated 1/12/24. Double C is state police report ending in 9804. Double D is Connecticut Board of Parole remain in custody order 2/22/24. Double E is notice of parole violation. Double F is parole violation report. Double G is notice of employee rights, and double H is the app program letter. And did you receive notice of parole violation report, and other documents I marked, and did you review them?
Yes, we did numerous times.
Okay, and council saw the following exhibit pre-mark for identification purposes as Exhibit 1 was parole accomplishments and future plans for program statement. Exhibit 2, at foundation letter from Tristina Onofrio. Exhibit 3, at foundation letter from Catherine D'Angelo. Exhibit 4, email from Michael J. Culkin. Exhibit 5, Boys and Girls Village letter from Cynthia Silva, parent educator. Do you need to continue hearing containing additional evidence?
So we do not.
We have no witnesses today. So at this time, the state will have an opportunity to speak to any of the evidence submitted at this time. So I am just going to swear Pio Castillo in as well as Ms. Morris. So if you'd like to speak at some point, you may. So will you please both raise your right hand? You solemnly swear or sincerely affirm as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury.
Yes.
This is something that I do.
Thank you. So Pio Castillo, if you'd like to say anything at this time in regards to violations?
No.
Okay. All right, so it's now defense opportunity, you'd like to speak regarding the violation.
As of the preponderance standard, we have gone through all these violations. The previous time with the fine tooth comb, there were no findings made. I think I can address the seriousness or the strength or the result of these without attacking them on a preponderance standard. So I'm not going to make any comment regarding the preponderance standard.
Okay. All right, so what I'm gonna do next is I'm going to announce my findings. So on charge 1, I do find that you violated condition, additional board condition, halfway house placement. These are on the dates of 11/16, 1/2, 1/3, 1/19, 1/21, 1/22, 1/29, 2/1, 2/2, 2/6, 2/7, 2/9, and 2/21. Based on the evidence that was provided, exhibits I, K, M through S, U, V, W, double W, X, Y, Z, and double C. All the dates are not taken into consideration, as no finding was made at them time of the preliminary hearing.
Can I just ask, do you have 13 dates? Is that how many dates you have there? Just count the dates. Sorry.
Yeah.
That's part of my argument.
2, 6, 7. How many I have?
How many you made findings on?
Have
By the preponderance on it.
11, 12, 13, 14. There's 15.
Okay.
Right, so that includes the fact finding portion. Before I make recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, council will have the same opportunity. This first part of the hearing is the final outcome I will recommend. So P.O. 50, do you have anything you want to say in regards to the second part of the hearing?
No, I don't.
Okay. So is now defense opportunity if you'd like to?
I have no questions of the witness. The words that ring out throughout are verbal aggression, temper, behavior, attitude, argumentative, disrespectful, and disruptive. We're only talking about 15 days out of a 10-month period. And the conduct itself, the earliest conduct is November 16th, and the latest conduct is February 21st. So we're really only talking about a 3-month period of 10 months. So from April 5th, 2023 to November 16th, 2023, we have no alleged violations. And then we have violations 15 days within the course of 3 months. I would argue and assert that they're all similar causes. They can all stem from my client's untreated anger management and mental health issues. And interestingly enough, that is what the recommendation of P.O. Castillo is in her report, in the violation report. At this time, due to continued noncompliance, which started at the beginning of referral supervision up to this most recent violation, which technically isn't true, we're only talking about a 3-month period, parole is recommending a period of incarceration, which would afford her the opportunity to address her mental health needs. But we all know that she's not going to get mental health treatment at your correctional facility. Parole is also recommending an anger management program be completed while incarcerated. Well, we also know she's not going to get anger management while incarcerated to assist her in addressing her anger management. Further, it is recommended at the completion of her term of incarceration that the mental health unit evaluate her parole mental health unit to see if she should be supervised by a mental health specialized unit. That's what we contend. If it is felt she needs to be more, it is felt that she needs to be more closely monitored and supported for her mental health compliance and treatment, and the additional support of a specialized parole officer would offer this support. And so it's our contention that she's not going to get any of that support incarcerated. She may have had a number, 15 days, where she was verbally aggressive, may have had a temper, just as assuming the facts in the light most favorable to the state. She has an explanation for all of these things. She does, and some of them are good explanations. And if you look at just a neutral party, Exhibit 4, I didn't ask for this, Exhibit 4 from her attorney, when she was talking on the phone with her attorney, he says, got it. If it is all help, I called Bethany to prep her for trial, and she was absolutely being berated for being on the phone with me. It was a no-win situation. They told her that she was going to be written up. She explained very calmly that she was on the phone with her lawyer and they could not care less about it. Told her that they were tired of her and that they were writing her up for breaking the rules, i.e. having a call. It struck me as very irrational and extreme. It made me feel sorry for Bethany at this time. I'm not sure if that information is useful to some. It's not easy living with the people you choose to live with in life. It's stressful living with someone. This is a situation where my client is living in a halfway house and she's not the only party. There are people that work there. There are other people that are trying to get help. Maybe this scenario was not the best for my client. Maybe we should take the recommendation of Officer Castillo and the recommendation in Exhibit HH of Catherine D'Angelo, APRN, psychiatric advanced nurse practitioner. Our foundation does not provide individual therapy, but rather medical management and substance abuse counseling for the new buprenorphine program. It is recommended, now this was written on January 31st. It is recommended at this time that Ms. Moore seek out and engage in individual therapy to focus on treatment for mental health, including current life stressors and PTSD. She's not going to receive the structure. She's not going to receive the type of mental health that she's doing with DCF. She's been compliant with DCF. Her main goal in her life right now, and has been, trying to reunite with her daughter. And from the letters that we've submitted from, the exhibits we've submitted from Boys and Girls Village, from ACT Foundation, my client's future plans are to get into structured mental health treatment, comply with all of the reunification treatment through DCF, to get into a sober house. She's amenable. She'd like to be placed in the Connections Reentry Assisted Reach program. She'd like to be placed in the Bridgeport, Connecticut, or New Haven. She wished to obtain her GED. She wished to do a project management program through Merit America Online. She's interested in returning to work with the founder and executive director of Women's Against Mass Incarceration, Diva Bain, while attending school. She would like to reunite and bond with her infant daughter. She's amenable to all treatment. Maybe it didn't work at the halfway house that she was at, but we're talking about 15 days of 10-month period, 15 out of 300, roughly 300 days. I don't think that these violations, she's a young woman, I don't think that these violations in and of themselves require a sanction of a long period of incarceration. She's already been incarcerated 60 days. She should get the fact that she's got to tailor her behavior to her surroundings. And I think all parties admit that what she was receiving wasn't sufficient. The treatment she was receiving, the monitoring she was receiving, and this is no disrespect at all. I think Officer Castillo did a fantastic job with my client. I think my client would agree that she's nodding in the affirmative now. I just think she needs different type of treatment from different professionals, not different parole professional, perhaps a mental health unit, perhaps different mental health treatment, because she seems to be succeeding with TCF. For those reasons, we'd ask that she be released as soon as possible, perhaps placed in a reach bed. She is on special parole. There are no acts of violence here. There's no crimes that were committed here. So I don't think that the violations taken by themselves, these isolated 15 days out of 300, is so serious to require further incarceration. I know she would like to speak.
All right, you can speak if you'd like to.
Okay. First and foremost, I would like to take responsibility for my actions. I have no excuses for them. So basically, my goal is to continue working alongside DCF. Sorry. My worker's name is Sophie Hale. I have amazing providers such as Quality Parenting Center, Circle of Security, Yale New Haven, ACT Foundation, WWAMI, Boys and Girls Village, IT support, project management. A big part of my plan is to work with Project Longevity. The best part will be upon release, I will go to 4 visits a week, reunification services, which includes supportive housing referral, which is amazing for the bond that I share because it's really hard. I've only had 2 visits since February 22nd due to the period of policy when you're in DOC, you only get 1 visit per month. So that's been really hard. I sit here known as Bethany Moore's inmate number 407380, but I'm also known as a sister to my wonderful brother, Michael. I'm a daughter to my father, Max and Tammy, who is battling to recover from 2 strokes. A woman I deeply love and is my best friend. But most importantly, I'm known as Mom, Mommy, and Mama to Cassidy, my breathtaking 16-year-old who loves to ride horses. Junior, who loves Batman and Joker and can't wait to put Legos together. And Winnie, my 7-month-old little mama's girl who loves baby sharks and snuggling. I have goals. And like I said, thank you for your time.
Thank you. I appreciate your statements. So I will put on the record, I know you have a prior top placement. I see no other, I don't see parole violations. I see a top placement. I see two misconducts that were received on this period of incarceration. So I am taking into account some of the no findings that I have made, as well as testimony provided. So I am going to make a recommendation that parole be revoked to be reparoled for May 22nd, 2024. It's about a 3-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, operation of a motor vehicle, mental health treatment, and behavior management program for anger management. My findings are going to go to the board on May 9th. If the board agrees with me, you'd be released on May 22nd. It sounds like you're aware of things that are going on that you've been having issues with. So I do hope that you address those now while you're in there before you get out, so you can continue doing that when you get out, so that we don't have these issues anymore. So you can stay outside with your family. And I hope you think about that, before things happen, and hopefully you won't come back here ever again. Do you have any questions about anything that was said? We're giving you the program. So we're going to give you anger management. We're going to give you these programs to help deal with some of the issues you have. I hope that you participate in the weekly therapy sessions like you've stated that you would like to do, and as well as if medication is needed, that you go that route and comply with all that, so that we don't see you again and that you're successful. So use your resources. You're on supervision for a while. So take advantage of what you have, and so you don't have any problems. We don't see you again. Okay?
Yeah. Thank you so much.
Call me on May 10th.
Okay.
That's a Friday. Talk to your counselor already. Set it up with me. We'll let you know what the board decided, okay?
All right. Thank you so much. Thank you, Pio Castillo. Thank you.
Thank you, Pio Castillo.
Thank you, Pio Castillo.
Bye. Have a good day.
Okay, so I know that the entire process was kind of long and it's not exactly that interesting, this specific hearing, but I thought I'd show it to you because we have all 3 in the process, and I'll show you more of these where it's all 3, because we're going to fast forward now to May 9th, where they actually do the final review. You'll see what it looks like, and you'll also get to see what Chance, Paige, and Dorgan look like, because we're going to see a video of them for this entire process. And after that, I'll just share some thoughts.
Examiner Vice here, today's May 9th, 2024. Can the board members please state your names for the record?
Panel member Page.
Joy Chance.
Panel member Dorgan.
This is a final revocation from Morris Bethany, number 407380. I recommend a revoke with a repro date of 5/20/2024 with the following conditions: halfway house placement, no consumption of alcoholic beverages, operation of a motor vehicle, mental health treatment, and behavior management program for anger management. Does the board accept or reject this recommendation?
Are there any objections?
None.
Officer Meisinger, was the field officer upset about your recommendation?
No. I
You didn't think so? Because I mean, did she offer no testimony, no, for some of the,
No, there was no recommendation regarding saying, just, they wanted a period of incarceration.
okay.
Longer than what you did, but.
All right, I move to accept the hearing examiner's recommendation and the conditions set forth. Is there a second?
Second.
All in favor?
Aye.
So we saw the process, and it was interesting because they actually said, well, did the parole officer say anything? Did she have any objection? They wanted to know. So I guess that shows that if the parole officer wanted to maybe stir up the water a little bit, they could have. But I think that I happen to be okay with the entire process, right? I think, I mean, the attorney, man, he's made some good points. It was like a 7-day period over 10 months, and I didn't think she was really, I think I agree. I think a 3-month sanction, which is what she ultimately got, so she's gonna get released now in like a week or something, and from the time of this recording, and I hope she does well. I think when all is said and done, justice was done in this case, right? But you tell me. I don't know. Hopefully we don't see her again. And thank you, Richard, for tying these all together. And with that, I'll let you